I love doing these types of programs. I do a lot of them down at the school, and I handle a good number of the foreign faculty and scholar visas for the university. I also represent a lot of high-tech companies, mining companies, a lot of, interestingly, I have a niche with professional basketball players. I represent a lot of foreign NBA players. So, and that's just something I fell into because I used to represent like 3 of the teams before the league took over visa work, and then all of the agents for the players now hire me directly to do their entourages for visas for their entourages. So that's always fun too. So, I figured what I would do is kind of give you an overview of the most common visas that are used with international companies, just to give you an idea of it. Obviously, if you have any, specific questions, feel free to share it for the Q&A. At that point, if you want to speak with me confidentially, that's always fine. Anita can put you in touch with me. I offer, we have a consultation fee at my firm. I waive it for anyone coming from the center. So just, feel free to call my office and say that you're with the U of A, and that fee will be waived, and I can at least answer your specific questions for you and your family. So Anita, what's the best way for me to share this PowerPoint?
Little box that says share screen.
Got it. Okay, here we are. So.
And we see it in your presentation mode. So yeah, if you go over to slideshow and one more over. You're on transitions, go over animation slideshow.
And right over, that's why, give me 1 second. Let me turn that off. And screen share is where?
No, yeah, we are already seeing it. So now you just want to go to the slideshow and do in presentation mode. So if you put your cursor up a little bit.
Yeah, the problem is that it's blocking me. Give me 1 moment, okay? I'm actually going to hop out for a second and then pull it up.
Because I know it's the 3-screen thing.
The Zoom screen is blocking it, so I can't.
Yeah, it's all good.
Give me 1 moment. I'm going to pop out. I'll be right back.
Of course. I know it's a thing. So yeah, whenever if you have any questions, feel free to put them in the chat. Like I said, we obviously don't want to have your personal questions there. And also, as Tarik said, if there's anything super personal, you don't have to share it here either. Tarik is really good about just, checking in with y'all, kind of understanding what your situation might be, and then just giving you some guidelines. Obviously, if there's then any work that they need to do in their firm, there would be a fee, but he's just really been fantastic providing his time and expertise to our folks here, just sorting out to stay legal is what we're trying to do. So, all right, Tarik, I see you're back. There you are. Perfect. So now we can't hear you, so. Tarik, you're on mute in case you.
Sorry. Okay, so again, here's all our contact information, but again, you can be put in touch with me through Anita anytime. So first, I like to kind of start with the general principle of how U.S. immigration works. Okay, we have 2 types of visas that you can use to come to the United States. The main one, we all know about the green card, permanent residency. That's called an immigrant visa. People who are not immigrating are called non-immigrants, people who are coming on temporary visas. And we have a bifurcated system, okay? The first is, and this is unique to the United States, we have a visa that is issued to you at the embassy. Many of you may have B1, B2 visas if you don't come on the ESTA for these visits. And so that visa is a little sticker that they put in your passport. All that does is allow you to board a flight and come knock at the door to seek entry to the United States. Whether you're allowed to stay in the country all depends on what happens when you actually enter. All right. When you enter, you show up at the airport, they issue you that I-94. They're now done electronically. And the I-94 is actually the critical document. That's what shows that you're in the United States lawfully. Okay. The visa is no longer important once you have entered the United States. You only need the visa to seek entry into the country. And the I-94 will show the date you entered, the status that you're here, which identifies what you're allowed to do while you're in the United States, that status. And that's usually one of these letters, alphabet, from the letter A down to the letter V. We have A visas down to V visas right now. And then the expiration date, the date that you must leave by. Now, many of you come here on the J1, I know, and the J1 is a little bit quirkier than that. When you get your I-94 for a J1, for your expiration date, you'll see it just says D/S, okay? And that stands for duration of status. And so with a J1, you have to look at both the I-94 and the DS 2019 form that you were given by your J1 exchange program. And the end date on your DS form is actually the expiration date. So the I-94 is then tied to your DS 2019. The visa and the status is one of those things that's unique to the US. Most countries don't have it. They just give you a visa, and that shows how long you're allowed to stay. Here we have the visa, but the visa is important for entry only. And then it's the I-94 that shows your status, how long you're allowed to stay, and what you're allowed to do. So that's really the important document. And sort of the best example I can give you of the difference in the two is, let me give you the example of a person who comes to the US on a student visa, okay, an F1 student visa. They have the F1 visa, they enter to come to, let's say, the University of Arizona to get a degree. And at the time they enter, they're given an I-94, valid for also duration of status. They have the same rule as the J1s do. And so that F1 student comes in, they have an F1 visa and an F1 I-94. Then the student graduates, gets a job, and the employer files to get, let's say, the student an H-1B work visa, okay, work visa status. That employer can file to change the student status inside the United States from an F1 student to an H-1B professional worker. And when that employer does that, the Department of Homeland Security will send the student an approval notice showing that the H-1B transfer was approved, and they will be given a new I-94 as part of their approval notice, which now says H-1B professional worker valid from this date to this date with a new expiration date, usually 3 years in the future. So what that student now has between the visa and the status is they're not aligned anymore, right? The student has an expired F1 student visa to enter the US, but an H-1B work status, which again is the important document showing what they're allowed to do while they're in the United States, okay? And just to kind of extend out that hypothetical further, the next time that person leaves the US, let's say Christmas rolls around, they want to go home for the holidays, the H-1B worker leaves, what do they need to come back into the US? Well, they have to get an H-1B visa now from the US consulate before they can come back and resume work, right? They can't use their old F1 visa anymore. Even if the visa hasn't expired, they don't want to enter on their old student visa because they're not entering as a student any longer. They would be entering as an H-1B worker, and therefore they need to get an H-1B visa. So we always have to keep track of both the visa situation when that expires and the status situation when that expires when we're doing a case. Now, there's a few different, these are sort of the main visa categories that I'm going to just give you an overview of today, because these are the most commonly used for international students, international workers, and transferees as well. And there are three main work visas that I'm going to talk about that have what's called dual intent status. And that's important because dual intent, it's a mental intent requirement. The general rule, if you're coming to the United States on a non-immigrant visa, is you're not allowed to have the intent to stay permanently in the country, okay? So if you come here as a student, you have to prove that you have an intention to return. If you come on many types of work visas or a visitor visa, obviously, you also have to show that same intent to return. They want to see your ties to your home country, property ties, family ties, whatever, and you have to convince the officer that it is a temporary intent and you plan to return to your home country at the end of that student visa or whatever it happens to be at that point. These three visas that I have up here, L1, H1B, and the E2, those are basically dual intent visas, which means that you are allowed to have the intent to remain permanently in the US, and they do not require that you stringently show an intent to return, okay? Certainly for the L's and the H's, you don't have to show it at all. With the E2, it's sort of a quasi-dual intent visa that's also a little bit more flexible on that issue. The other work visas that I'm going to kind of cover with you today, these are mostly free trade visas. They are pure non-immigrant intent visas, meaning that when you get those visas, you do have to demonstrate an intent to return to your home country. The B1 is the business visitor visa. The TN is the NAFTA visa, trade NAFTA visa, available to Canadians and Mexicans. The E3 is a free trade visa for Australians. And the H1B1, which is unfortunately named because it sounds like an H1B, but it's not. They're actually very different visas from that standpoint, the intent standpoint. The H1B1 is a free trade visa available to Chileans and Singaporeans. So I'm going to talk about the L, H, and E first, and then we'll talk about those non-immigrant visas as well. Before I do that, I do want to talk to you about the visa that probably many of you come here on, which is the B1, the business visitor visa. Again, it is a non-immigrant intent visa, so you do have to show an intent to return at the end of your temporary visit. But there are certain things that you're allowed to do in the business context as a B1, a business visitor, where you're not actually doing productive work, but you're allowed to do certain things short of doing productive work and being paid for it in the US. And there are a number of cases. The main one is matter of HERA, which is sort of an interesting case I can tell you about in a little bit. But the gist of what activities are allowable as a business visitor, which is always the first thing we look at because it's very easy and quick to get, particularly if you're from an ESTA country, is you can come for to engage in commercial transactions, taking orders for goods manufactured abroad. That's a big one. In fact, that's what happened in the matter of HERA case. What happened in matter of HERA is it was, I believe, an Italian tailor, business tailor, who came to the United States, and he was taking orders for bespoke suits that he was going to make back home in Italy. And so he would come in, he would meet with the clients, he would have them sign their contract to make their bespoke suit, he would measure them, and then he would return to Italy to make their suit and then ship it. That was questioned, it went up to the court system, and ultimately the board ruled that that was an allowable activity because the actual productive work was being done back in Italy. He was just coming in to sort of negotiate the contract and take measurements, and that was not sufficient to violate his business visitor status. So that kind of gives you an idea. It's very common. It's a very common scenario for the B1. The other one that's very common is short-term training, and that can be training either way. The foreign national can be coming to the United States to receive training or to give training. So if you work for an international company and you're sort of high up in the company and they want you to come here and do some training for their US workers, you should be able to do that on the B1 business visitor very quickly and easily without having to go to the trouble of getting an actual work visa, as long as it's short term. People always say, what does short term mean? It's not defined in the regulations, but I always say probably anything 90 days or less should be satisfactory, because that's the longest period of time that a B1 or a business visitor can enter if they're from an ESTA country. All right. Negotiating contracts speaks for itself. Consulting with business associates, same. If you're coming in for purposes of litigation to testify in a deposition or whatever it happens to be, or to appear for meetings related to some sort of litigation involving your company, you can come in. Obviously, conventions, seminars, conferences, those are all covered as well, and to undertake independent research. I mentioned I represent a lot of foreign professional athletes. There's also an exception for people coming in to try out for a team. Right now, if you're an NBA fan, there's the NBA combine going on right now where the players are being tested for the draft. They can come in as B1s, all the international players, in order to do that. Now, one of the main things, if you're coming in as a business visitor, is you're not supposed to be paid in the United States for services rendered, right? That would be approaching work. And providing any skilled or unskilled labor in the US is generally considered to be work. So if you are coming in as a B1 to do one of those activities, we do have you carry a letter that you can present basically saying they're coming in to do one of these acceptable activities only. They will not be paid directly from a US source. They will only be paid by their foreign employer while they're coming in to do these things. However, there is an exception that certain expenses can be paid for by a US source. So let's say you are asked to come give a speech at a university or something like that. You could come in as a B to give that. You can't be paid for it, but they can cover certain expenses for you. And that, meals, lodging, laundry, basic services like that. If you're coming as part of an international company, XYZ company in the US and XYZ company in Brazil, and they're having you come to the United States to perform some sort of training on the staff here for the US company. The US operation would be able to cover those expenses, your meals, your lodging, your laundry, while you were here doing that. That's one of the few things that they'll allow you to do as long as you're not being paid for your actual service. The regulation does specifically say that you can only be reimbursed the actual reasonable expenses, lodging and meals and so forth. So I always recommend to companies that the worker pay the costs and then just seek the reimbursement directly on a reimbursement form rather than per diems, which don't really hew closely enough to the wording of the regulation. Okay. If you have any questions about Bs, we can talk about them now, or if you want to hold them over till the Q&A, we can do that too. I'm going to move into the other visa categories and then.
I actually have a question about B1.
Sure, please.
So.
And
of course, yeah.
That's my fault, Nick. Sorry about that.
that way we can do the video better. So
That's
thanks.
right. And yeah, that's right. We're keeping it to this for the posting purposes. Okay, so yeah, please do save your question and then we'll get back to it at the end. So with the L1, now this is the international transfer visa. This is, any international company that has a major presence in the US and abroad, or even smaller companies can also qualify for these. Okay, you don't have to be Sony or something like that in order to do these. I will tell you that back in the 90s, when I was first practicing, we used to routinely do these for small companies. Small 4 or 5 man companies wanted to transfer 1 or 2 workers to the US. I once did one for a Canadian doctor who just wanted to open a clinic on the US side. And so I got a 1-person L1 for him to open up his clinic on the US side so that he could also serve patients here. Over time, the government has become a little bit more tight in the issuance of L1 visas for very small companies. I would say that only have a handful of employees. But they're still technically there. If it's a strong case, you may want to give that a try. But generally, you want to have a decent sized company. And what I tell people is, if you're going to be transferring someone to the U.S., make sure that there's still a substantial presence in the foreign entity. And if the person is a manager, you want to be able to show who's going to be replacing that manager after he or she transfers to the United States. So there are 2 types of L1 visas, and this is the the major international visa. The L1A, which is for managers or executives, and the L1A is a visa that is initially issued for 3 years and can be extended for a total of 7 in increments of 2 years each. The person has to have been employed as an executive or a manager with the company abroad for at least 1 of the prior 3 years. It's not just a flat 1-year rule. It used to be long ago. They made it 1 of the prior 3 years because they wanted to make it a little bit more flexible. If you had a person who was a manager at a company and she left the company for a year and a half, but then came back, they wanted that person to be able to go ahead and be transferred on an L1. Or if the person left within the last 2 years, you could still do it, of course. So it's one of the last 3 years. People will ask, what does it mean to be a manager? Generally, what the government looks for, I will tell you, it's more broad than this, but what they always look for first is this person managing and supervising other degreed professionals? If so, they're normally satisfied. The more the better, but it doesn't have to be a lot. 1 technically needs it. 2 or 3 is usually sufficient for an L1A. And that's what the first question that we usually ask. Do they supervise? And if so, are those people who were supervised degreed professionals? If they do not, there is also something called a function manager, where if the person does not directly supervise other people, but they supervise a role of high importance in the company, you can argue that as well, argue a functional manager. The person is the vice president of finance. They run all the finance operations for the mid-sized company, but they don't have anyone working under them. Yes, they hire outside accountants and so forth. They manage the function, the financial functions of the company, but they don't have direct reports. That could be a functional manager. Those cases do have a higher rate of denial, but they can still be approved if they're presented properly. Another benefit of the L1A is that there is a fast track to the green card for that category. So if the person has come here on an L1A visa and the employer wants to sponsor them for a green card at some point, there's a faster way to do it. And they get to skip what's called labor certification, which is sort of the most heavily regulated area of employment immigration. That's the protection of the U.S. worker provision, where the employer has to advertise and recruit and demonstrate that they couldn't find an American to fill the job. They do not require that of L1A managers or executives. You know, again, using Sony as an example, if Sony wants to transfer a VP here to manage an operation or an office, they're not going to make Sony prove that they can't find an American to fill that job first. They're going to go ahead and let that international manager go ahead and just go straight to the green card. Another benefit, and this was recently liberalized, is that spouses of L1As can work. And they're called L2, the spouse. Historically, the spouse, if they wanted to be able to work, they could do it. Since around 2004 or so, they made it optional. So the spouse had to affirmatively apply for a work card if they wanted to work. And that was getting to the point where it was taking the government about 10, 11 months to issue the work card, which was a huge waste. They'd come in, they'd have a 3-year visa, and then they'd have to wait a year just to be able to work, the spouse would, or same with the extensions. You'd file an extension, the extension would be granted right away, but the work card would not for another 10 months. So then they'd have a 10-month gap in their ability to work. So last year, the Biden administration got rid of the work card requirement and just said, forget it. It's a blanket eligibility. If the person enters as an L2 spouse, they can work just by virtue of being an L2, and they don't have to get the separate optional work card any longer. And again, the other benefit of the L1A here at the bottom, you'll see, is that dual intent status, where they are allowed mentally to have the intention to, and the company can seek a green card for them safely while they're on an L1. So that's for managers and executives. There also is an L1 visa for special workers, people who have some sort of special knowledge of the company, and the company wants to bring them in because of that special knowledge that they've acquired over time. This visa is very similar. It's initially good for 3 years, but they can only, L1Bs can only get 1 2-year extension. So they have a total of 5 years on that visa. They also have to have been employed by one of the affiliated companies abroad for one of the past 3 years. And they, instead of proving that they're a manager or executive, they have to prove that they have specialized knowledge. And that is, specialized knowledge of the company's products, services, research, et cetera, and their application in international markets. So basically, a lot of people will say, can I just get an L1B after 1 year? The answer is technically yes, but it will still be somewhat subjectively viewed in the eyes of the officer who you're seeking the visa from, right? So some officers will say, yes, you've been there for one of the past 3 years. However, the knowledge you've acquired in that year is not necessarily specialized enough. I can tell you that if the person's worked for the company abroad for 5 or 7 years, they're going to be able to show specialized knowledge pretty easily. Person's been there for 1 or 2 years, you never know. Too much of it depends on the adjudicator you get. And then it's fighting scale in between. Okay. There's also a process called a blanket L1. This is available to larger companies that process at least 10 L1s a year or have, I think it's, gosh, I can't remember, 25 million in sales or something per year. So if you have a larger company, you can get what's called a blanket where they will pre-approve the company for L1 visas. And all you have to do is send the worker directly to the consulate to prove that they're a manager or a specialized knowledge employee. You don't have to reprove the corporate relationship of the US and the foreign operation like you normally do on every other individual L1. So if you are with a larger company and you're interested in that, I can certainly explain that in more detail to you. My understanding at the center is that it's mostly startups, so I'm not going to spend too much time on blankets. There's also a visa called an E2. This is not available to people from every country in the world, but there is a long list of countries that have a bilateral investment treaty with the United States. I know that you have several Ukrainians. Anita mentioned that, so I went ahead and looked up when our bilateral investment treaty was signed with Ukraine. It was signed November of 1996. So for sure, Ukrainians are available. You know, Australians, Canadians. You know, it's very easy if you don't know if your country has one. It's very easy to do. Go into Google and type in E-2 countries, and the very first search result is the State Department website. You click on it, and there's about a 12-page list of countries that have a bilateral investment treaty. And you look to see if your country's on it, and if it is, you're good. You only have to be a citizen of that country. So if you have multiple citizenships, that's also something to look for. If you don't have it through your birth country, you may have it through the other country that you have dual citizenship through. Now, one of the requirements is that the company that is formed in the US by a national of one of these treaty countries, it has to be at least 50% owned by, in this example, Ukrainians. So if you have a company that is at least 50% owned by Ukrainians, then you can send any Ukrainian workers to the United States to work for that company under the E2 visa. So that's a great one. So they can be an executive or supervisor under an E2, sort of similar to the L1A. They can be an essential employee, sort of similar to the specialized knowledge L1B, but maybe not quite as stringent a standard. You don't have to show specialization, just that they're an important employee to the US company. These visas are valid for 5 years at a time, generally. It depends on the country you're coming from. Some have a shorter period, some are 4 years, but they are indefinite. So you can renew them indefinitely as long as you want that worker. Unlike the L1, which has a 7 or 5 year cap, this does not have a cap. You get it 5 years at a time, but you could be here for 20 years on that type of visa if you wanted. Spouses of an E2 worker also enjoy the unrestricted work authorization. They liberalized it along with the L spouses last year. Same thing. L and E spouses no longer have to get that optional work card in order to work. They can just work by virtue of being here on that status. And that is about it as far as E visas go. The other major visa, and this is sort of the workhorse professional work visa, the H-1B, you hear about it all the time, sort of a political hot potato in the United States, and a frustrating visa. And the reason why it's frustrating is because Congress only allows 85,000 of these visas to be issued per year. And initially it was 65,000. That limit was set in 1990, before Al Gore invented the internet, as I like to say, and the H-1B became such a big blown up visa that once we hit the tech economy in the late 90s, the 65,000 visas was woefully inadequate for the needs of the American business. Congress did create a second H-1B packet of 20,000 visas available for anyone who has a U.S. master's degree. So total now is 85,000, still woefully inadequate. And the procedure is a little bit weird, and I'll get to that on the next slide, so let me save that. But the basic principle of the H-1B is that the job that's being offered to the worker must customarily require a bachelor's degree or higher in the field. And the Department of Labor has all of these treatises that purport to state what the customary requirements are for every job in the world. So if you can go into that system, look up your job, and it will say in there, customarily a bachelor's is required, or customarily something less is, or customarily a master's is. And that's something that the Department of Labor kind of ties to. If it's a job that commonly does not require a degree, they will say the H-1B is not available, okay? Now, let me give you the example. Obviously like a software engineer, those types of folks, customarily a degree is required for that. If it's a nurse, nurses in this country customarily don't require a bachelor's degree. In this state of Arizona, a 2-year associate's degree plus an RN license is what you need. So nurses generally cannot get an H-1B because the job does not require it. They might have a bachelor's in nursing, the nurse you want to hire, but because the job does not customarily require it, they won't allow you to get a nurse in H-1B. There are exceptions to that. If it's a nurse manager or a specialty surgical nurse for cardiothoracic, something like that, and you can show that customarily in the field a bachelor's is required because it's a higher level of nursing or something more precise, you can do it. But that's sort of the idea of it. And then, once you have confirmed that that DOL agrees the job requires a degree, you have to find out what the prevailing wage is for that job in that area. So in this example, we would look for a software engineer in Tucson, and up comes 4 different wage levels. And depending on the level of the engineer, the Department of Labor will tell you which level you need to select. The employer must pay at least that salary or higher, okay? You always hear these complaints, oh, we shouldn't bring in all these foreign workers because they're undercutting US wages. That's not true. By law, the workers must be paid the customary rate, the prevailing wage for that job in that locale or higher. They can be paid more, but they can't be paid less. So if that company is a company that's not paying its workers the prevailing wage, the company says we paid our workers $55,000 a year, and we do the prevailing wage analysis, and it comes back at 60. We go to that employer and say, well, you're going to have to pay the foreign worker $5,000 more than all of your U.S. workers. So the answer basically is that foreign workers might be paid more, but they're never going to be paid less as the U.S. workers. And actually what that is meant to do is sort of incentivize employers to actually pay all their workers more, because then of course, if you hire a foreigner paying them $5,000 more, then the other workers are going to say, why is Sergey making more than I am, kind of a thing, right? So then everyone's wages are theoretically lifted under the scheme. That's what the government was aiming to do. So that's sort of the general principle of the H-1B. Now, as far as the cap, I mentioned the 85,000 cap on these visas. The U.S. federal fiscal year runs October 1st to September 30th each year. And so on October 1st is when each year the 85,000 visas are freed up. By regulation, the earliest that an employer can file an H-1B is 6 months before the start date that's being requested. So what that means is that the earliest an employer can file an H-1B each year is April 1st, 6 months before October 1st. And what we used to do until 3 years ago is every employer that wanted an H-1B had to prepare the entire case, submit it with the entire fee, the filing fee, and wait and see whether it was approved. And what the government would do is when they got all these filings on April 1st, they would then announce, we've already received more than 85,000. Please don't submit anymore. We're done for this year. And then they would hold the lottery to see who got the 85,000. They would issue the 85,000. And then sometime in July, those who were not selected would get their entire packet mailed back to them with their filing fees and everything, okay? They went to a smarter system a few years, 3 years ago. And the new system is in March, they do sort of a mini H-1B filing, and it's done electronically. And it's called the H-1B cap registration. So an employer wanting to hire someone registers the worker, and it's sort of a mini one. Here's information on our company. Here's information on the worker. Here's the job we intend to hire him or her for if they're selected, and we are registering them here. Ends up being tremendously cheaper than putting together an entire case and having to submit it, not knowing if it will ever be adjudicated or not. And so what happens then is this year, I think that the dates were March 8th to the 18th, I believe were our dates for registration. And then they announced before April 1st who the 85,000 selectees are. And if you are selected, then the company has between April 1st and June 30th, 90 days, to file the H-1B for you, requesting a start date of October 1st. Okay. And so that's the current procedure we have. Now you can see, I mentioned the 65,000 regular and the 20,000 masters. They hold two lotteries. Okay. They used to hold the regular one first and then the masters one, or excuse me, vice versa. They used to do the masters and the regular. Now they do the regular and then the masters. So this last March, we got 781,000, if you can believe it, registrations for those 85,000 slots. And I'll show you on the next slide how it's just been growing year after year after year to the point that we've gotten to this absurdity where it's just obviously woefully inadequate, these 85,000, but we cannot get Congress to agree to issue more of these. It's just very frustrating. So that's where we are now. This is the explanation I just gave you for the creation of the cap registration. And this kind of shows you the way it's grown over the last 15 years, okay? Back in 2008, right before the recession, the terrible 2008 recession hit, on April 1st, they received 163,000 filings for the 85,000 slots. So the odds were not too bad, right? A little better than 50-50 overall. And in fact, if you had a master's, US master's, your odds were very good. They were about 80% chance of selection. Then, of course, the recession hit, and in 2009, we didn't run out of visas until December. So we didn't run out in March. April ran all the way into December before we ran out of the 85,000. The next year after that, we went all the way into January before we ran out. And then as the economy started picking up steam and we started needing workers again coming out of that recession, in 2011, you'll see it then shortened and we ran out in November, then we ran out in June in 2012. And we knew when that happened, we were going to go back to the days of running out on the first day in April, and that's what happened, right? So ever since 2013, we have gotten more filings than we needed on the first day. So we were at 124,000, odds were pretty good of selection, and it's literally just grown every single year. We had one little drop back here from 2017, 2018. And then it just took off like crazy since then. You can see 4 years ago it was at 2,201, then to 274, then to 308. Last year it was 483, and this year it's, I mean, we're jumping exponentially now. Last March at almost 800,000 registrations. Now, one thing that's a little quirky is this. When they set up the cap registration, the government, and many of us suspect they did this so that they could get more registration fees. They said that workers could have multiple employers filing petitions for them, so long as it was a bona fide job offer, right? So out of these 781,000 registrations, 408,000 of them were actually duplicates, meaning 408,000 were for the same 96,000 workers. So these 96,000 workers had 4 or 5 registrations done for them, depending ballpark, you know, on average. And now the government's very upset that all these people were filing multiple registrations, saying that that's fraud, even though they allowed it under the thing. So now they're trying to figure out a way to dissuade people from doing it. I don't know if they're going to raise the filing fees, because I know the government, they're not going to want to give up those filing fees. but they want to try and tighten this up in some way. So I expect there to be more changes to this system before next year. Something addressing these multiple filings. The most I've ever done is I've had a couple of workers who had 2 different companies filing for them, but they were bona fide job offers from those companies. So because we made the H-1B such a nightmare, other countries are sort of taking advantage of it. Canada for a while had a program where if you had ever held an H-1B in the United States, you could just get a green card in Canada. And it was sort of an amazing thing. They're very smart. Ireland also had sort of a similar program, trying to get H-1Bs to move there. The US really has, the public policy on this is terrible. These are all professional jobs, high wage jobs, high tax benefit jobs to the economy. Why we would want to restrict them? The companies want them. The worker wants to be here in that professional job, paying those taxes. But for some reason, we've decided that we're too stupid to to expand the H-1B program so that they could stay here and do it. And so what ends up happening is they either have to go work for that same company abroad, and the job ends up being outsourced, so the tax benefit goes to that country, or they just go to another country entirely and work for a company that competes against our US companies. So it's really a very short-sighted policy that we currently have, but it's been like this, honestly, as long as I've been a lawyer. They just can't get it together politically to do the right thing on this. Now for some good news. Once you've been selected in the CAP, if you're transferring from company A to company B, you do not have to go through that CAP registration again. Once you're selected, you are good for up to 6 years on that H-1B. So if you get an H-1B with a company and 2 years later, they're like, we don't have our ability to get you a green card, or we're not looking to make it a permanent position, and you wanted to transfer to another company that's willing to sponsor you for a green card, you can do that. You can transfer at any time. And the only restriction is that you're limited by the 6 years. The number of years you've already been with company A will be charged against your 6-year total. So if you've already been in H-1B, say for 4 years, you're only going to be able to get a 2-year H-1B with that new company. And basically you and that company both know you have 2 years to get through the green card process. Otherwise you're going to end up having to leave. Okay. So you always want to calculate how much of those 6 years you still have left if you are acquiring an H-1B. But you as employers, if you're with the company and you get a resume of a person you want to hire who's on an H-1B, just know you can transfer them. You don't have to go through that CAP, that nightmare. You could actually have them working for you within a couple of weeks. It's just that the one question you do want to know is how much time do you have, so that we know that we'll have enough time to get you through a green card process so that we don't lose you in 2 years in that example. It's also portable, meaning as soon as the employer files the petition for you, you can begin working for the new employer. You don't have to wait for the approval. I do tell them that if it's an iffy question, whether it would be approved for whatever reason, you may want to wait for that approval first, just to make sure that the person doesn't leave company A and leave themselves exposed. Because if the petition by company B is denied, then they've left company A and they're now out of status. So sometimes it's safer to stay with that one until the approval and then move. They also, where'd I go? They also created in 2017, President Obama, 2 days before he left office, this regulation went into effect. And what it does is it created a 60-day grace period. So if you're on an H-1B work visa, used to be if you were fired, you were out of status that day. So not only did you lose your job and your salary, you also lost your ability to remain lawfully in this country that same day, and you had to immediately leave. So they created a 60-day grace period to give people time to pack their stuff and deal with their effects before they needed to leave. Or if they wanted to stay, they would have 60 days to find a new job offer. And as long as a new company files an H-1B petition for them within 60 days of their termination, they're considered to have maintained lawful status throughout. And that's it for the 3 dual intent visas, the H, the L, and the E. Now I kind of want to take you through the various free trade visas for those 5 countries that I mentioned. The first is that H-1B1, and again, I hate this name of this visa because it sounds like an H-1B, but there are really significant differences. The main one being it's a pure non-immigrant intent visa. You only are allowed to have the intent to come in temporarily and not to seek permanent residency on that. It's valid in 1-year increments. It does not have a limit. So you can get 1-year H-1B1s indefinitely. You just have to keep renewing them each year. And the requirements are the same as the H-1B, meaning it has to be a job that customarily requires a bachelor's or higher degree, and the worker has the degree in that specific field or in a closely related field. The other free trade visa is the E3, that's from Australia, also tracks the same requirement, specialty occupation, that same, the job must customarily require a degree in order to do it. It's also a pure non-immigrant intent visa. The E3 for Australians is valid in 2-year increments. And also the other huge benefit of this one is that spouses can work. And they work again by virtue. It used to be they had to get the temporary work card. They no longer do. As of last year, they were also included. So that's a wonderful visa if you come across an Australian professional. And then the last one is the NAFTA, the trade NAFTA visa, also a non-immigrant intent visa. This one does not track the same language as the H-1B. With the NAFTA visa, there's actually a list of professions. And if you work in one of those professions and have the relevant educational background that's listed in the NAFTA, usually a bachelor's, but not always. So some of those positions you can get without a bachelor's. Then you can get the TN, and that's a wonderful one as well. It's valid for 3 years. For Canadians, indefinitely renewable. Because there is the non-immigrant intent question, even though there's not a hard cap on the number of years you can be here on that visa, if you're here for too long, say you're on one for 12, 15 years, it's not outside the realm of possibility that one day you could be denied and told, you've been here for so long that we are now concerned you're developing the intent to live permanently here. You should have gotten yourself a green card by now if that's your plan, but you're not supposed to be living here for an eternity on a temporary visa like this. However, I've also seen TNs walk in my door who've been here for 20 years and it just hasn't come up. So it can be either way. But normally with a TN, I tell them, once you hit year 6, 7, 8, let's start talking about permanent residency if you're not planning to return at that point. Canadians are visa exempt, so they can prepare their NAFTA and go straight to the border with it. They don't have to file anything beforehand. Mexicans do not have that luxury. They do have to go get a visa at a U.S. consulate first, and then they can enter. Their visa can be valid for 4 years, but the status, the I-94 status, cannot exceed 3 years, okay, when they enter. And spouses cannot work on that visa, unlike the E3. And here is the list. I'll send this to Anita so she has it. You can click on any of these, and that way you can pull up and see what the list of professional categories. Or you can also just Google TN professional categories, and they will pull up the NAFTA appendix showing you which jobs are there. These are the most common ones probably that we work with. Accountants, engineers, systems analysts, graphic designers. But there's all kinds of physicians and dentists and lawyers and nutritionists and psychologists. I mean, there's lots of different types of jobs. But I would say that the engineer is probably the most common TN category that they see. And so that's it for the non-immigrant visas that I wanted to cover with you as well. And I just wanted to give you sort of a quick overview of the green card categories, just so you have an idea, the immigrant visas, and then we can get to your questions. We have 3 major preference categories for permanent residency through an employer, okay? First, second, and third. The first preference category is for extraordinary ability aliens. It's called an EB1A. And that is for people, it's sort of the genius category, right? The creme de la creme, people who have achieved the very highest stature in their field nationally or internationally. I mentioned I represent a lot of professional basketball players. One of the gentlemen who I used to represent, he's retired now. but he was a two-time MVP of the NBA, right? Best player in the league 2 years in a row. And I called him and I said, it's time to get your green card. And I filed this. When you look at the regulation, what it says is, this is for a person who has won the equivalent of the Nobel Prize in their field. And so I asserted that winning the MVP, the most valuable player award for the NBA, was the equivalent of the Nobel Prize in the field of professional basketball. And it was the thinnest application I've ever filed. That's all I submitted, and they approved it. I was sort of taunting them to see if they would question it, but they didn't. They approved it. When you go through the regs, it says if they've won the equivalent of the Nobel Prize in their field, you're good. If they have not, you can still meet it alternatively by showing that the person has achieved 3 out of 8 various criteria. And the criteria are, they've been the author of original scholarly work, they're highly paid, they've judged the work of others in international symposia or whatever it happens to be, they're well published, there's lots of publications about their work, they are a member of an organization requiring extraordinary achievement. And so we basically lay out these criteria and then try to assert that they meet as many of them as possible and attach expert opinion letters from people in the field nationally and internationally. Some have worked with the person, some who have not, but just know them by reputation. And we file that and say, this person really is extraordinary in the field. Those cases are never slam dunks, no matter how strong, other than maybe my one basketball player. And that's basically it, so you file it, they're very subjective. The government also has a policy of doing a totality of the circumstances and saying, even if you meet the 3 criteria, 3 of the 8, you still have to show that overall as a package, it establishes your extraordinary ability. And that's a wonderful one. So if that gets approved, then you go straight to the green card afterward. Also in first preference are outstanding professors or researchers. I do a ton of these for the University of Arizona. Most of their professors, are outstanding. And so this is the category I normally seek their green cards through. Again, very similar type of criteria to the extraordinary ability, but it's not quite as high a standard. They do have to be very well published and so forth. The international transferee manager and executive. I mentioned earlier that if you come as an L1A manager or executive, there's a fast track to the green card. This is what I was referring to, this category, because this allows them to skip that labor certification, that market test to prove that there's no Americans to fill the job. They don't have to show that. They just have to show that they were a manager or executive for the company abroad, and they're now being transferred to the US to be a manager or executive. Second preference, those are for jobs that customarily require an advanced degree. So, very similar to the H-1B, they don't look to what the degree is the person has, but what the job requires. So if it's a job that generally in this country requires a bachelor's degree and the person has a master's degree, that's not going to qualify in the second preference. Okay, that's gonna be in the third preference, a bachelor's degree job. It's the job requirement that's customary that will assign whether you're second or third preference. If the person has a master's and it's a bachelor's level job, they just exceed the requirements of the job, but it's still going to be a third preference job. Okay. Also, as part of second preference, so for instance, a physician or someone like that, that would be second preference. Right? What did I just do? That would be a second preference job. Or a professor, they always require a graduate degree. Also, a person who's doing some sort of job that is in the US national interest. These are, it could be a COVID researcher, a COVID doctor. It could be a food supply person. It could be a water safety person. It could be a transportation worker building bridges. It could be any number of things that are in the US national interest. Then you can also put them into second preference. And then third preference is, like I said, very similar, just for the bachelor's level or lower level jobs. You can also do through third preference. And when you're doing a second preference or third preference job, other than the national interest waiver, they all require that you go through that labor certification process where you advertise, recruit, and demonstrate that you didn't find a minimally qualified American to fill the job. And this is the procedure basically. So I just took you through the categories. This is the general procedure for the green card. The first is that labor certification, and that is where that heavily regulated recruitment campaign that the employer goes through. That process right now runs about a year to a year and a half, closer to a year and a half to get through. And basically, you take the position, you break down all the duties, you deconstruct each duty and identify which skills are required to perform each one of those duties. And then you go to the worker and work with them to show how they acquired those skills prior to joining the employer. Okay. And the reason why you have to go through that whole mechanism is the employer is not allowed to require any skill while they go through the recruitment process. They cannot require any skill that they have given to the foreign national. Okay. And the theory there is you could have hired a US worker and given them the skill on the job. So you should not be able to use knowledge of that skill against US workers in the recruitment process. So we always have to identify all that to make sure that the person already had those skills prior to joining the company as an H or an E or an L or whatever it happens to be. And then we can go ahead and do the labor certification. They also have to be paid the prevailing wage. So we have to do the prevailing wage, but when you do a prevailing wage for labor certification, the Department of Labor has to tell you the wage. So that slows down the process. We know how to do prevailing wages. We do them for all of our H-1Bs. We can get them done in 15 minutes. But when you do a labor certification, you have to submit it to the DOL, and the Department of Labor right now takes about 7 or 8 months to send you the wage. So it really slows down the process. You get all the drafting done, it's all ready to go. You submit it to find out the wage, and then we sit around twiddling our thumbs for 7 months waiting for the wage to come back so that we can begin the recruitment campaign. Then once the labor certification comes back and it's approved, okay, the DOL comes back and they certify, hey, you filed this, you only had 3 applicants, 2 of them didn't even have the right degree, 1 of them didn't want to move to Tucson or wanted a higher salary, whatever it is. We're certifying that there were no available US workers for this position. You then go to the Department of Homeland Security here at Step 2, the immigrant petition, and that's where the employer basically says, hey, Department of Homeland Security, DOL has already certified there's no workers available. We want to hire Sergey. Here's the proof that he met the requirements for the job before he ever joined our company. And we want to fill that permanent position with Sergey. Here's all of his accolades, and here's our ability to pay that prevailing wage requirement. Okay, so we have to submit financial records as well. That gets approved very quickly, usually in less than a month. Then you wait until a visa is available. And there's a chart that the State Department issues every month, basically stating which visas are now available. And they go by the date that the labor certification was filed. So you'll see up here, I have under labor certification, the date filed is your priority date. What that is let's say we were filing a labor certification today for Sergey, since he's my hypothetical name today. And we file it today. Sergey's priority date will be May 19th of 2023, okay? And you think of that date as sort of a number in line, but instead of giving you a number in line, they use the date that you filed. And then they issue this chart showing what date they're at each year. And then once your date comes up, that's when you can file for your green card. Your permanent residency application can go and be submitted, all right? And just let me skip ahead just to give you an example. So right now, worldwide, EB3, a bachelor's, well, let's go do an EB2. Let's say Sergey, we filed Sergey's labor certification in October, okay? And it just got approved, and the I-140, the immigrant petition was just approved. And his October 1st, 2022 priority date, we're looking at it, can we file that for him? And we go to the chart for this month, for June, upcoming month, June 2023, and it says December 1st, 22. What that means is, if Sergey's priority date is October or December 1st, 2022 or earlier, he can file for his green card in June of 2023. So that's the way it's all kind of broken down. And as you can see, the backlogs are not really very severe for EB1, 2, or 3, first, second, or third preference. unless you're Chinese or Indian. The Chinese have multi-year backlogs, so they will sit in this waiting line for a year or two before they can file that step 3, watching that chart to get to their priority date. But the poor Indians, you know, they get their I-140 approved, they're going to be waiting 11 years to be able to file that green card. So Indians really have it bad as far as this goes, and you can see why Indians, whoa, not quite sure what I just